Hello everyone, I am Sai Chaitanya Choda, currently pursuing the first year of 3-year LLB program at DSNLU Vizag. Before we step into today's topic, let's quickly rewind the journey of this series. In episode 1, we explored the fascinating origin of Madras, also known as Chennapatnam. We look at how the small coastal settlement gradually came under the control of the British East India Company, how the historic Fort St. George was constructed, and how the town was divided into two distinct parts: White Town, where the Europeans lived, and Black Town, where the native Indians populations resided. That episode set the historical foundation for understanding the colonial administrative structure. Then in episode 2, we moved deeper into the general administration of Madras. We discussed the executive authority and the various administrative departments that governed the settlement during the early colonial period. However, we intentionally left the judiciary because the judiciary system itself is a complex and requires several dedicated discussions. Many institutions and officials repeat across different phases, often with unfamiliar names, so it deserved its own detailed series of explanation. And that brings us to episode 3. In this episode, we are going to begin our exploration of the judicial system of Madras between 1639 and 1726. More specifically, we will focus on phase 1 of the judicial administration, the period from 1639 to 1665, which marks the earliest stage of legal and judicial arrangements under the British East India Company in Madras. So let's now dive into episode 3. Judiciary of Madras 1639 to 1665. Phase 1. Early judiciary system in the settlement 1639 to 1665. Judiciary system phase 1. In the about the phase 1, there is no large information or recorded information, so it was very less information about this early stage of judiciary in Madras settlement. So let's look at it. What we have the information about this phase of judiciary in Madras settlement. As I said before, very much information is available regarding the early judiciary system in this settlement. Justice was dispensed to the inhabitants of the White Town by the agent and council. Whoever resides in White Town, they will go to appeal to agent and council for the district for the justice. The scope of the judicial power is very vague and indefinite, and therefore they restricted in handling serial criminal cases and very often refer such cases to the company authorities in England for advice. So, in the Charter of 1600, they did not mention the power of the judiciary or establishment of courts. What is the power or jurisdiction of the court? So, they get feared for taking up serious cases. So immediately they consult or send CS cases to the England company authorities company authorities in England for advice as communication. But yes, at the time, communication between India and England in those days took very long time because like today there is no mobiles or anything else. Only the communication goes through letters only. So the administration of justice become very dilated and sensitive. So these long time communication gaps make the justice system dilute, remains no seriousness and unsatisfaction among the people and along with the in the bodies, judicial bodies or company bodies. The only available account of case disposed of during this period is that of two Englishmen who were found guilty of sedition and were punished with the lash. So sedition. So at this time, there is only one case, which is two Englishmen were punished with lash and found guilty for sedition. Which means in legal time, sedition is the legal term for overt conduct such as speech, writing, or organization to incite rebellion or insurrection or violence in the settlement or established government, and it acts as a bridge between criticism and treason, often aiming to disrupt public order or overthrow the authority. So now let's move to next slide. Next, coming to the black tone cases. Through Raja had left, the local Raja who we already discussed, Chennanaika and Venkatadinayaka. Through the Raja had left the responsibility to the administrator, the black tone to the English. As we said before, the Raja, Venkatadinayaka and other guy, other Raja, they left the to the English that even the black tone cases also decided made decisions and according to the English law. But the Englishman did not evince much interest in the aspect of at this time in black cases because there is no regular judicial tribunal was established and the old traditional indigenous systems which had been operating in the village of Madras Patnam before the advent of the British was allowed to continue. So lack of independent or lack of regular judicial tribunal, the British East India Company allowed the local laws and local judicial procedures to continue in the rule also, in the administration also. So as a part of local judicial systems, the Chowdhury courts were established with Adigar, who is act as a judge to decide small civil and criminal cases. At the time, Kannappa got the post of Adigar, which is inherited from his father, and he abused his power as Adigar, I mean judge of Chowdhury court, in various ways, the most serious of which was that he convened the stealing of children for being sold as slaves. So he was convinced to and said that stealing children and being sold as slaves is not a guilty offense. So finally, this made East India Company August and removed him or dismissed him from the office in 1652. And from then, two Englishmen started sitting at the shoulder court as the judges. The childhood courts were merely a court of petty cases at the no other courts created at this time, like very small cases, like theft, smaller robberies, like that. So there is no other courts was created at this time, and also no much information is available about the methods and used for the purpose of child reports. So some vague areas can, however, be formed for sundry offences to some cases in the records of the period. In 1641, an Indian was accused of murdering the woman with whom he had been cohabiting. After some sort of a very informal inquiry, he was found guilty of the offense. No formal trial was held. A few questions were asked, his house was searched, and they found the clothes and jewels which made him guilty, and those clothes and jewelry become the primary evidence. So, as the agent and the council asked or communicated the findings to the Raja, local Raja, he immediately said that the justice be done according to the English law. But so the accused was hanged. So at the time, maybe this is the first case where in modern India or in colonial era, first man to get hanged by Europeans. Maybe in 1642, a British soldier was killed by a Portuguese. The council was unwilling to deal summarily with a subject of an European power. The Raja, however, ordered that the accused be executed, and therefore the man was shot dead. In 1644, Second Bradford killed a native by incident instead of trying Bradford themselves. The agent and council referred the matter to the principal inhabitants of Blacktown, who brought in a verdict of death by accident. This procedure appears to have been adopted presumably because the crime had been committed against an Indian. Key observations. If the key observations at this time in a early legal system is there is no established procedure as we discussed it before. These accounts cover several things. First, there was no fixed formal trial procedure. Usually, the methods resorted to for the purpose were informal trial of serious crimes committed by the Indians or by other against them appear to have been conducted on an ad hoc basis of the procedure for the same varied from case to case according as it was thought expedient in the circumstances of each case. Secondly, the agent showed some interest when serious crimes has been committed in the Black Town. In capital cases committed by persons other than British, reference was usually made to. In secondly, the agent showed some interest when a serious crime was committed in the Black Town. That means the agent was showed more interest in Black Town cases compared to the White Town cases. In these capital cases committed by persons other than British, they started going local larger and who were accused to be punished according to the English law. So we saw the reflections of the or demerits of the early colonial legal jurisdiction. It is possible that the practice arose because the agent and council lacked power to inflict death sentence under the Charter of 1600. As we said before, the Charter of 1600 is the sole constitution of East India Company and it did not allow any East Indian officials to grant death penalty to anyone, death sentence to anyone in whatever the case and how serious is that case. So if they want to inflict death sentences, they must have to take the permission or advice or refer the case to local sovereign rulers. And if the local sovereign rulers are also said or order to give sentence, then only they have to implement death sentence. Other than on their own, they don't have power to implement death sentence on their own. It may also be that the British administrations did not want to cause any annoyance to the Raja. So it is on the other hand, we can think that British should also think that we came here for trade, so we must respect the powers of Raja and we don't uh, cross our limits and we have to maintain friendship with them. If we give death penalties without asking Raja, it will make cracks and ties with local rulers. So in the fear of that, they did not want to give sentence that much quickly. And executing an Indian without his prior consent might have created some misunderstanding between human. Yeah, as I said before, it was like that. This situation, however, did not last very long. So it was not gone very long. So then this period is therefore conspicuous by the absence of any systematic and regular administration of justice. The judicial methods were elementary. The system, if it can be called a system at all, consists of two bodies, two administrator justice, the agent and counsel for the White Town Chowdhury Court for the Black Town. The former was not efficient as it was a very hesitating sort of court and was not sure of its power. The Chowdhury Court could decide only petty cases. For trial of serious cases arising in the Black Town, there was no established procedures of so if there is any serious cases like rapes, murders, etc. happen, then there is no legal trials for trial process for to deal with those type of cases at that time. So this is all about the phase one judicial system. Next, in the next episode, we are going to move about the history of Madras, episode 4, which is deals with secondary phase, which was a large part of it, and we have to know much more deeper, and we can get more and more details about how they established the judicial system and how they learned the mistakes from the previous decisions. Okay, that's next week we will meet with episode 4. Thanks for watching. Please like, share, and subscribe and comment. Thank you once again. You are Sai Choda.